This is a brief video responding to a few common questions about the impact of COVID-19 on the landlord-tenant law. The information shared in this video does not constitute legal advice or the formation of an attorney-client relationship. This is solely for informational purposes. Today is June 10th, 2020, and these are landlord-tenant updates as of today.
Can a landlord refuse re-entry to a tenant diagnosed with COVID-19?
No, a landlord cannot refuse a tenant from re-entering the apartment if the tenant has been diagnosed with COVID-19. If, however, the landlord has concerns about the tenant's health, they should contact the health department and let them handle it.
Can a landlord lock out a tenant for non-payment?
No, a landlord may not, under any circumstances, lock out a tenant for non-payment. If a tenant is locked out of their apartment, which is constructive eviction, they can sue the landlord for treble damages, for example, 3 times the rent that they pay.
What can tenants do if they can't afford the rent during this pandemic?
Executive Order 202.28 prohibits a landlord from locking out or threatening a tenant with eviction for non-payment. This order gives a tenant a grace period from June 20, 2020 until August 20, 2020 to make arrangements to vacate the apartment if they are unable to pay the rent during this pandemic. If the tenant has given the landlord a security deposit, the tenant can use the security deposit towards the payment of rent, which under normal circumstances is usually prohibited in the lease contract. Please note, the executive order does not waive the rent obligation due to the landlord, but rather only allows the tenant to stay in the apartment until August 20th, 2020. After that date, the landlord has the right to initiate an eviction proceeding in the court and obtain a warrant of eviction from the court before the landlord can evict a tenant.
Do tenants have to notify a landlord if they tested positive for COVID-19? Does a landlord have to notify a tenant if another tenant has tested positive for COVID-19?
No, tenants are not legally obligated to inform their landlords that they have tested positive for COVID-19. And conversely, a landlord does not have to notify a tenant if another tenant has tested positive for COVID-19. Furthermore, a tenant who has recovered from COVID-19 is under no obligation to tell the landlord that he has been previously diagnosed. Of course, tenants should still use precaution when dealing with the public or while in common areas of the building or apartment.
What should a tenant do if their landlord locks them out of their apartment?
Call 911. The police must enforce and protect the tenant's rights.